And with all this in mind, you wish to prosecute reference to the assault.
Yeah, so it'll make it safer. I don't know if were you guys here before?
Yeah, we're just here.
So that lady was trying to get into the clubhouse and we were working out, and I don't think that she's supposed to be coming in, so we weren't allowing her in. And then she was asking these kids to let her in, and I told them don't let her in, because I was a little bit nervous. She was out there talking to herself, and you guys were just here and we were just whatever. So she saw me say that, and she took a chair and she started to slam it into the glass door.
Did it break?
I don't know if it broke. It might have cracked.
Told me.
John, do you have your records?
Are you inside?
Yeah.
Okay. What did she do?
She took those metal green chairs and threw them out the door a bunch of times. At the window. At the
Yeah, I saw.
door.
We have a video.
Nothing broken.
Guess not, but we got really scared, so we called you guys.
Listen, we're having.
Because we're the ones that look like the bad guys who told on her.
Did y'all move the chair back?
What?
Did y'all move the chair back?
She put it back because she saw me starting to video her, and then she stopped.
Okay, well, I mean, there's no damage. I thought the glass was broken. How it sounded when the call came out. That's why I actually come. But it was like just only this person tripped or whatever.
You had the video?
You saw?
Yeah.
You saw her doing it?
We were looking to see if she had left. I couldn't tell who was in here.
We were.
Yeah, Dennis was here before.
Yeah, but he left, and I was like, don't let him go. I am scared. But she didn't realize how scary she could be.
Get her information.
Can I have your ID?
I don't live here, but...
Well, you saw what happened.
Yeah.
Don't come outside. Stay in your house and watch the
How did she even get through the gate unless she's not allowed to come to the clubhouse? Somebody let her in?
People let her in. I mean, nobody knows.
Okay.
Yeah. And then she left.
Okay. So, I mean, when I'm done with all this, I get some paperwork.
Sorry.
Okay.
You know the whole backstory, what it's all about?
Yeah, I was here. I was the first one to the whole board thing.
Right. So
That was me. And that still trickled on onto this to like a month or two later?
she got suspended. I mean, she didn't show up for her hearing.
Okay. All right, man. Raise your right hand. You swear in affirmative, but it gave us the whole truth and the truth?
Yes.
All right. So tell me what happened tonight.
So we were in the clubhouse working out, and there was another guy in there, and we saw the police actually while we were about going in.
Okay, so
With the lady.
we was here before with her. Okay.
Yeah, and then we went in, and we said, what's going on outside, to this guy that was working out, and he said, the lady that's been doing these parties and making money at the clubhouse or whatever is in trouble, and the cops came, and we said,
what was that lady wearing?
A black shirt and pink pants.
Okay.
And so we asked what's going on, and he said, whatever, she's in trouble. So we said, okay, and then she started to come to the clubhouse and try to get in, and she looked like a little frazzled, and I don't know if she was on the phone or talking to herself or what, but we were told the guy, because I was a little nervous, because I was she's trying to get in, and we were 3 girls there.
When did she try to get in? After we left?
Yeah.
Okay.
She was trying to get in, and we didn't let her in, we just ignored her. And then there was kids at the pool, and she was trying to ask them to let her in. And they were starting to let her in, and I got nervous, and I said, don't let her in. And then when she saw me do that, she picked up a chair and started throwing it at the glass door. And she was looking at me. I couldn't hear what she was saying, but she was it looked like she was saying yelling or whatever. She was upset. And I got nervous that the glass was going to break. She was going to get in, so I called 911.
You guys were in the main area of the clubhouse.
Yeah.
Working out, and the kids tried to let her in. You guys said no. Why'd you guys say no?
I did. Because I had seen that she was just in trouble, and the guy that was there before said don't let her in, and I was a little bit nervous because she, I don't know, I just was scared.
You were scared?
She was just with the cops. and I didn't know what. I don't know. I just there's nobody there.
So you were afraid that she was just with us, law enforcement. You didn't know what she was trying to do coming in. You're afraid. Okay.
And the guy told us don't let her in, and I just knew she was like kind of in trouble about other stuff.
Were you in a sense afraid because something was going to happen to you and your friends, or when you say you were afraid, how were you afraid for yourself? You were afraid for everybody?
Yeah, I mean, we were three girls there alone, and I just didn't know. She seemed a little bit erratic, and I know she was just with you guys, like I said, and I just didn't know what was going to happen. So. Okay.
And with all this in mind, you wish to prosecute reference to the assault?
Yeah, so it'll make it safer for everyone here, I guess.
It's not an I guess. You don't say yes or no.
Okay, yeah.
You're willing to prosecute? Okay. The whole statement you just gave is the whole truth and the truth?
Yeah.
There's no absent information that you're forgetting to tell me? How you doing? Alright, from here again, okay? Alright, I gotta read something to you. Alright, I'm required to warn you before you make any statement you have fallen custody of rights. You got the right to remain silent, answer my questions. Any statement you make must be freely and voluntarily given. Do you understand these rights to be read to you?
Yes, I do now.
And you wish to speak to me?
I don't have a reason not to.
I need a yes or no.
Yeah.
Okay, alright, so what happened after I left, or what happened to me and my partner left?
I had to go pee. So I asked the young lady that was coming out of the pool if she could let me in so I could pee real quick. And she said, sure, no problem. But when she went to open the door, somebody from the inside was like doing I don't know, but like she saw it. I didn't see it because I was facing the pool. And she says, I don't know what's going on. They don't want me to open the door for you. So I said, okay, no problem. So I sat back in the chair. And then this was a gentleman in there earlier, Dennis, that had told him not to let me in the clubhouse. He was also the one that attacked me at the clubhouse a few weeks ago. And the police said that as long as he didn't touch me, they couldn't do anything to him. And he's been up there harassing me a couple of times. But they finally came and went to his house and told him not to bother me. He told the girls not to let me in. The young lady and her brother left, or they went to the tennis court. And then I went and knocked hard on the door. All I wanted to do was use the bathroom and then come home. I'm still sweating. And then when I saw they wouldn't let me in, I went to the side, came home.
Okay.
I'm just still trying to cool down from all the heat and exhaustion, and that was it.
So how were you able to access the clubhouse?
When I don't know his name, but we walked in together. It was me, the young lady, and her brother. We walked into the clubhouse, not the clubhouse, but the back, the sitting area.
Okay.
And I sat there. I didn't bother them. They didn't bother me. They swam, and I sat there just trying to cool down. But then when I had to go to the bathroom, I said, "Could you let me in? I just want to go to the bathroom real quick." And that's when the girls were talking to them about not letting me in. So I sat there for a while. Then I knocked hard on the door, and I just left.
Okay.
I just left.
But from the prior instance where we're here, you're not allowed at all at the clubhouse.
Our community regulation says that if a homeowner does something that you believe is a violation, the first thing that has to happen is a hearing. So the hearing, I've never spoken to the board about their concerns. All I've been getting, and I could show you, threats after threats, email after email, not getting in the gate. It's just been a lot. I have not gone to their house. You see, I call you guys if I need you. I don't touch people. I don't go harass them at their house. But I wanted to use the bathroom, and you could ask those two kids. They actually walked with me. I came here and they went to their house. They were like, they don't know what's going on. And I'm like... Oh.
So you're aware that you can't go to the clubhouse. That's all that with the community, that's a civil matter. So you know that you're not supposed to be there. So you said you wanted to cool off or use the bathroom. So a reasonable person would say, you live 5 houses away from the community. Wouldn't it have been wiser to walk home than stay in the area that you're not supposed to be?
The rules of the community says that you cannot remove access block, clubhouse, pool, when it is a non-monetary violation.
All right. Again, we're getting a little off track here.
Yes.
All right. So while you was out there, you did the statement you said about you were at the pool.
I was sitting down on it.
Sitting in the pool. You
No,
tried to
not
ask somebody
in
to
the
get
pool.
inside. Somebody
Yes.
inside said whatever in reference to another incident.
No, I was
the
not
lady won't let
involved
you
with
in.
that. The young lady from the pool and her brother went to the door.
They tried to let you get in.
Yes.
Okay,
and
cool.
then somebody said something
Said
to
about
them.
another to not let you in.
And I was like, don't worry, it's okay. So the brother and the sister started leaving. And then I got up
And you left.
and no, I hit the door. It wouldn't open, so I left.
You hit the door or what?
I hit the door with what?
Yeah. You said you hit the door.
Yeah, I hit the door with my hand. The chair that was behind me.
You used the chair?
No, when I backed up, the chair hit the door.
You backed up? The chair hit the door?
Yeah, because I was sitting, let's say this is the glass, so the chair was like this. My chair was like this. This is the table, so I'm like this. So I'm looking at the pool. I wasn't even looking inside, I was looking at the pool.
You stand up, the chair hit the door. Okay. Continue. And
Yes, because what happened
you
is-
hit the door with your hands.
No, because when the kids came from the pool, I had to move.
Okay.
So when I moved the chair so they could come and do the gate thing. And then they were there trying to get, so when I sat back down, I told them to leave, they left. And when I stood up, it was like the power of the chair hit the door.
Okay.
Then I left. I was like, you know what? They're not gonna let me in.
All right. So with everything you just told me, that's what happened tonight.
Yeah, I didn't do anything to nobody. The only person I talked to was the sister and the brother.
The sister and the brother that was outside by the pool?
Yes.
Or no, you didn't talk to nobody inside?
No.
What were you saying to the people that was inside?
I didn't say anything. Because, they were acting scared and everything. I don't know what Dennis told them because they really looked frightened. And I don't know what he told them.
Okay, no problem. Do me
I don't know
Do me a
that.
favor though. Stand up. Stand up. Put your hands behind your back.
I did not assault anybody,
Hands together like
officer.
you're praying. Hand palm to palm like you're praying.
I did not assault anybody, officer. Can we call a supervisor? Because when Dennis, the same guy that was in there tonight, came in there and assaulted me, they said as long as he didn't touch me, because I didn't touch nobody.
Well, assault's not touching people.
What is it?
Okay.
So we'll explain it to you. We'll read it to you verbatim.
I didn't do nothing to that sis. What did you say it was?
What was that?
What did you say it was?
What was?
Assault?
Assault.
How could I assault somebody when I'm not even in their presence?
Well, sit in the car, I'll explain it to you. Just take a seat for me. We'll get the air going.
But I need my medication.
Yeah, what medication was that?
I need my medication box.
What's your name?
But I did say that I need my medication, so can we go get that?
We'll work on that in a second,
All right.
not right this minute, okay? Are you getting enough air back here? Can you feel it?
Yeah, it's good.
Watch your knee. I'll be right back.
It's all good. They're always scared of black people. Aggravated assault. I didn't even see those girls. I don't know what he told those girls. We'll figure it out. We'll figure it out. Bet you if it was a white person, I'd have a seatbelt on. How the hell I take it off? How can I put on my seatbelt? You're neglectful. Not me. Like, how am I gonna put on my seatbelt? I'm handcuffed. And he's talking about I took off the seatbelt. Nobody never put on the seatbelt.
Look away from me.
Look away.
Yep. I said look away, not move your body away.
Ridiculous. You charging me a criminal offense for a chip on the door?
Criminal mischief is criminal mischief.
I didn't do that. And that door has 1,000 chips. You guys always overcharging black people. Because I'm sure there's 1,000 chips on that door. Which chip? No, I'm not going to stop.
You know that, right?
Huh?
You're still under Miranda. Anything you say.
I don't care. I'm telling you that you cops do not treat everybody fairly.
So I thought you didn't hit it with the chair.
I did not. That's what I told you. I did not chip the door. I did not touch any place.
So the video is not you?
The video is me, but I didn't damage. The door's not damaged. I left the pool and I walked straight home. Where did I cause a scene? With whom? There was nobody in the pool area. When I walked home by myself. So who did I disturb? You guys could charge, but never want to explain anything.
Okay, so what do you guys think about that one? Now, this one, I don't have the woman's name, so I can't look to see if this case is done, if it's over, if she sued this community thereafter, or anything. But let's look at the laws at play here. Once again, we're in Florida. We got several laws we'll look at. Some of these were charged according to Police Watch. Some of them weren't. First, assault. That was not charged according to Police Watch, but it is exactly what the police officer asked that Jewish woman if that's what she wanted to do. Assault. This is found in section 784.011. It's simply defined as when you intentionally threaten someone by word or act, and that threat has to be unlawful. The person has to have some apparent ability to complete the threat, and the act has to create fear of imminent violence. Right here, we had a chair that was being hit against some glass. You had some women on the inside that said they were afraid and they called 911. All right, this potentially meets the elements. The penalty here is a second-degree misdemeanor. That's up to 60 days in jail, a fine of up to $500. Now let's talk about a small twist on here. Now she wasn't charged for assault. She also then wasn't charged for this next one, which is aggravated assault. But I want you to know what the difference is between them, okay? This is found at 784.021. It says this is an assault with a deadly weapon, but there's no intent to kill or with the intent to commit a felony. All right, so you see what they get the aggravated form of this assault. You got to either have a deadly weapon or you have to be doing this with the intent to commit some other felony. So the reason this could have come into play, now if she was doing the assault in order to get on the property and not leave, that would be the trespass, then they could go for aggravated assault. It's just a logic problem, guys. When you're dealing with what is going to be charged, they're trying to see what elements they can meet and which ones are going to give the most punishment with the least amount of effort to meet those elements. Here, a chair is rarely seen as a deadly weapon unless it's used in a manner likely to cause great bodily harm. When you pick a chair up and you're going to use the four legs to hit something else, then it can be seen as a weapon, okay? But in these circumstances, her being on the outside with the chair, her not really being in close proximity to the other women, it's not going to be seen as a deadly weapon. Now, if the facts would change a bit, now if she were actually able to shatter that glass with that chair, yes, all day. Because just the simple act of that glass shattering and the noise and the excitement it's going to cause, yes, that's going to be assault all day. Now, aggravated assault is a third-degree felony. So that's the lowest level felony in Florida. It carries the 555, 5 years in prison, a fine of up to $5,000. You might get 5 years of probation. Now, the next one. This one was charged criminal mischief. This is found at section 806.13. It's defined as when you willfully or maliciously damage property that's not yours. Now, criminal mischief is all based on the value of what was damaged. All right, anything less than $200 is a second-degree misdemeanor, and that's up to 60 days in jail, a fine of up to $500. Now, if we're talking about between $200 and $1,000, that's a first-degree misdemeanor. That's our 111, up to 1 year in jail, a fine of up to $1,000, potentially 1 year of probation. Now, anything more than $1,000 is considered a third-degree felony. That's the 555. Now, here, this whole charge is going to really survive on how much the damage actually was. Now, chipping some glass, that's nominal damage at the most. They might be able to fix that glass without even having to replace the whole pane of glass, the whole panel. So here you have very little damage. It's probably going to be resulting in that second-degree misdemeanor level. Now, was anyone else surprised that glass held? I know I was. All right, but next, trespass in a structure. This is found at section 810.08. It's defined as any time a person willfully enters or remains in a structure without authorization or after a warning to depart. Now, what we heard about today is that the police have already showed up, all right, and there's already been an incident prior. So, according to, I guess, the authorities, the HOA, she's been banned from that place. So that banning from there, if she had proper notice, because that was an issue here, then if she tried to come on that property and remain, she would be liable for trespass in a structure. All right, our final charge, disorderly conduct. She was hit with this. This is found at section 877.03 of the Florida statutes. And it's defined as any time a person acts in a disturbing manner it's going to disturb the peace or the public decency. Now here, there were some children present while she was doing all this. But this charge of disorderly conduct, you can beat this charge in court, okay? I think that once they settle everything, most of these charges might be dropped, okay? She could probably pay whatever it costs to fix that door. Now, she has some issues she's going to have to deal with the HOA. And we'll talk about that maybe a little bit more in the jury section. But let's move into our evidentiary standards, because remember, they're going to apply every time we have a police interaction. Okay, let's deal with our evidentiary standards. We'll start at the lowest and work our way up to the highest. Let's begin. First, we have mere suspicion. Now, at this level, the police can't take any real action against us. This is when they only have a hunch, but no proof. Here, if the police are just receiving a call, they don't have any proof just yet to make any action. They have to come and take a report and figure out what's going on and investigate. But when there's just a call to come out, there's an issue. Many times, the police can't come out and take any action just yet. Moving up one level, reasonable suspicion. Now, at this level, the police or the government have specific and articulable facts that suggest that there's some criminal activity afoot. What are we talking about here? Talking about a witness saying that someone clearly used a chair from outside and tried to break into this room. At this level, the police can detain and they can investigate. They can question a person to figure out what exactly is going on. Now, this is a brief detention. We're not talking about holding a person for 2 and 3 days. Just long enough to find out what's going on and if there's enough here for them to go ahead and effectuate a full arrest. Moving up a level, we have probable cause. Now, at probable cause, the police or whatever government agency you're dealing with is going to arrest somebody. At this stage, there's enough evidence to build a connection between the crime and the suspect. Basically, there's enough here for a reasonable person to make the conclusion that there's a crime that happened and the suspect is involved. Anytime you hear that word probable cause, just remember somebody's getting arrested. Here, it's the same information. You got witness statements. We got a surveillance video that does inside the clubhouse and right outside the clubhouse. So they're seeing everything. There's enough to meet this standard of evidence. Let's move up one more level to preponderance of the evidence. Now, this is the first level where people are going to be able to bring someone to court and sue them. This is where they're at, preponderance of the evidence. This means that your claim is more likely than not to be true. The only thing required to win is 51% of the evidence in your favor. The only thing required to lose is 51% of the evidence out of your favor. All right, here, this is going to be civil level where people are going to sue for contracts, torts, all those sorts of things. Now, this is the level where I suspect she's going to be dealing with her HOA. They're going to be dealing with her for the near future, dealing with whether she has access to that clubhouse. Moving up one more level, we have clear and convincing evidence. Now, this is also one of the civil standards, but you use this level of evidence when you need a person to have more evidence in their favor to win. When the action is going to require, in order to understand what's going on, more evidence. We're talking about the type of cases where you're saying somebody defrauded you, or if you're claiming that if we're fighting over children, the children need to move from one house to another. Clear and convincing evidence is required anytime we're going to need more receipts. To win these type of cases, you need about 75% of the evidence in your favor. Substantially likely to win your case when there's a high likelihood that what you're talking about is true. Now, once again, we talked about the HOA and how that might be at the preponderance level. Now, it could be, it's depending on what they're talking about, what they're bringing. If they want to ban her for good from being able to use that property, in that situation, they might have to bring this case and have clear and convincing evidence. All right, finally, let's get to the highest level, beyond a reasonable doubt. Now, at this level, the government has to meet this level for every criminal case. What this means is there's no other logical conclusion besides the defendant being guilty of the charges brought against them. To meet this burden, the government is going to need to have anywhere between 90 to 95% of the evidence in their favor. This is not an easy burden to meet. Now, they would use things like the video, the testimony of the witnesses. In this type of action, when this goes to jury trial, I think the jurors are going to wonder, why is this even going on here? And they're going to want to know more of the story behind this. But let's move into our jury perspective. Let's ask some questions about this situation. All right, imagine yourself on this jury, and let's ask a few questions to see what's going on. Now first, does this video show a willful strike with the chair or an accidental bump while moving? Now, you saw what I said there, that people lie so much. It's almost a given. When you're going to court and somebody's looking to get in trouble for what they've done, the first excuse might be a lie. All right, how about this one? Did the witness have a well-founded fear of imminent violence? Or was it just a general unease? Are we able to easily identify the threatening act against her? All right, next. Was the woman clearly ever told she could not enter? We've heard about prior suspension and some HOA hearing that she didn't appear at. Did they ever send her mail, or did someone go take something to her house? Was there some real-time refusal that was done that we didn't see? And the second part of that question, did she enter or remain on the property after being told she couldn't be there? I think with this one, this is going to be a hard one to prove, because they're going to need to show the process that she had noticed that she couldn't be there. Damage. Now, with criminal mischief, it all depends on damage. Repair costs. Less than $200, it keeps it minor. I would suspect the glass on that door is not going to be more than a couple $100. And I'm not really sure if they would need to replace the glass on the door if it's only got a chip in it and doesn't show any signs of being a safety issue where it's going to break or anything of that nature. That had to be some reinforced glass or something. All right, and finally, as a juror, we have to always make sure that we set aside our preconceived notions, stereotypes, biases. And there's usually going to be a jury instruction that you receive that always says that you're to use your common knowledge, but you can't be biased in favor of or against any of the parties, lawyers, or witnesses to this case. So if we set aside the HOA politics and the race-based claims, we would focus only on the elements and the evidence available here. So what do you think? Guilty or not guilty? And of which one of these? You tell me, let's discuss. All right, our takeaway for today. First, the big one. Now, if you live in a neighborhood that has some HOA rules, those don't control criminal law. They provide notice that can turn the dispute into trespass. Assault is fear-based. No touching is required. All that's needed is threatening acts that create some well-founded fear. Now, as to criminal mischief, that's always going to require some proof of damage, and you got to have a value. Once you have that video, and as long as it can show just one clear chip, that could decide intent, fear, and entry. If you find yourself in a situation like this, de-escalation, that always is going to be a key term. It's always going to matter, especially when you're talking about places with shared amenity, your apartment complex, your exclusive luxury neighborhood. When emotions spike, step away, document, and report. All right, like the video, subscribe, share the video with someone else. Leave some comments and let's discuss this. Remember, this is Advocacy Alchemy, and I am Professor Ross. I'll see you tomorrow. Everyone have a great day. Stay safe out there. Don't fight with your neighbors.
If you've got ideas or videos you want me to lecture on, send them to the queue. And come back tomorrow at 8:45 a.m. for another lecture.